Hello, good afternoon. Hello.
Hello, good
Hello, Mina.
afternoon.
Good afternoon.
Good
Hello, Mina, good
afternoon.
afternoon.
Good afternoon, Regina the stranger. Good afternoon, Julie, Miriam, Edmond, and all those. I think I've seen Louise. Uh, and how is everybody today?
Yeah, all doing fine, thank you.
Hi, Mina.
Doing well.
I believe Stanley is having issues with his microphone. So can we give him about 5 minutes if for him to sort it out?
Sure.
Okay. Stanley, so we are waiting on you if you can hear us. After 5 minutes, we'll just see how it goes. In the interim, Louise, I haven't heard from you in a very long while. I think the last time we met was last year, I think.
Yeah, I think so. I'm trying to think when it was.
I think it was it in SA?
Could have been in Stellenbosch.
Yes, yes.
That's right. That's
Yeah,
right.
yeah, when we had
Hello.
Stanley,
Oh,
are you back? Oh, good.
Do you hear me?
Yes, we can. Okay, I can.
Yeah, we can hear you.
Okay, good to hear that. I'm sorry, not sure what happened, but it's all sorted. Good afternoon from Abuja. My name is Stanley Ibe, and I have the pleasure of moderating this session. On behalf of our host, the Commonwealth Human Rights Initiative, I would like to welcome everyone to this important discussion on declassifying minor and petty offenses in Africa. We have an extremely knowledgeable panel to discuss these issues. They are going to be reflecting on questions such as why minor petty offenses are such a burden on the continent, what has been done about this category of offenses, what challenges confront advocates and institutions working in the field, and what more can be done. I encourage everyone to engage with the conversation in the way that they deem fit. Please listen, note your comments and questions. We have reserved about half an hour to engage with the audience. So rest assured that you have some space and scope to reflect on the issues. It remains for me to introduce the panelists and invite them to lead the conversation. But before then, let me ask Mina Mensah, who heads the opening remarks. Mina, please.
And thank you very much, Stanley. And I've already said good afternoon when you were sorting out your mic. As Stanley has said, we are here to have a conversation on minor offenses. This was triggered because as part of the decriminalizing work that CHRI is doing in collaboration with all the stakeholders, we realized that the advocacy has been heavy on petty offenses, decriminalizing petty offenses, which ought to be. However, when you look at the principles, the African Commission principles of decriminalizing petty offenses, it talks also about pet offenses, minor offenses that do not meet the threshold, but that need to be also looked at. We had an experience whilst we were doing the work. We wanted to compile a petty offenders registry, a register in our prisons in Ghana. And we realized that you can hardly find anybody like that in our prisons. In the first place, Ghana has no classification of their offenses. There's nothing like petty offenses. There's nothing like minor offenses. We have misdemeanors. And there are a range of offenses that you can get up to 5 years in jail. So if you steal a bunch of plantain, depending on how the judge decides, you might get the upper limit. And we find a lot of these people in our prisons in Ghana. And they help to choke the prison. Apart from that, their rights are not respected as they ought to be. And the overuse of these sentences actually does not help anybody. And so we decided to put this together to have a conversation, because there are countries on the continent who have alternative laws for these things. Fortunately for us, just this week, at the bar conference, which is still ongoing, we've been engaging the Attorney General, and he came out at the bar conference. He talked about the non-custodial sentencing regime that we are working on. And the bar itself is also calling for the state to look at our sentencing regime in terms of minor offenses. So this conversation is really good for us. And we can add some of the things that we benefit to the work that we've already done and presented to the AG to facilitate looking at our laws and redefining them to fit into modern times. Like Stanley said, we have very experienced, knowledgeable team around. The panelists have been doing this work for a very long time, and we are here to learn. Please, let's engage. Let's bring our views. Let's share our knowledge, information. Let's ask our questions. And beyond that, let's also advocate in our various countries if we do not have laws that facilitate promoting more humane sentences for minor offenders. On that note, I would want to welcome you and also say that let's enjoy ourselves and let's have a very fruitful conversation. Thank you. Stanley, we can't hear you.
Hello, do you hear me now?
Yes, we can.
Okay, excellent. Thanks, Mina. I will go quickly to the bios of our panelists, and then we get straight into the discussion. The first person on the list is Luis Elas. Luis is Senior Program Manager in the Open Society Foundation's Global Programs Justice team. Previously, she was a unit manager with OSL's Human Rights Initiative. The focus of our work today has been on supporting activism to prevent the erosion of human rights protections and challenge discrimination, impunity, and threats in democratic space, with a particular focus on justice, security, and accountability. Before joining HRI in 2014, Luis held various positions within the Open Society Foundation's network, including as Law Program Manager at the Open Society Foundation for South Africa. Open Society Initiative for Southern Africa, and as a Program Director at the Open Society Foundation for South Africa. Hello?
Stanley, we can hear you now.
Can you hear me?
Yes.
Yeah. She has experience working on human rights across the African continent and in South and Southeast Asia, Latin America, the Middle East, and Eurasia, as well as managing a portfolio of global justice grants. Luis holds an MPhil in law, a Bachelor of Commerce, and a Bachelor of Social Science. She was a visiting scholar at Columbia University's Institute for the Study of Human Rights. Throughout her working life as a practitioner and later in philanthropy, she has been committed to holding the rights of the most marginalized and challenging discrimination and exclusion in all aspects of public life. The second panelist is Edmond Foley, who Africa, based in the Gambia. Foley is a Ghanaian lawyer of over 20 years post-qualification. He has devoted the last 15 years of his career to working on the African human rights system. And public sector legal about 10 years experience in legal and political risk analysis with a focus on the human rights-based approach. Among other roles, he previously served as a technical advisor on children's rights at Ghana's Ministry of Gender, Children, and Social Protection between 2014 and 2015. Our next panelist is Julie Mateka, who is the program manager at the International Commission of Jurists, Kenya. She's also a member of NCAJ Criminal Justice Committee and member of the National Steering Committee on Alternative Justice Systems. Julie holds a Bachelor of Laws from the University of Nairobi and a Master of Laws from the University of London. She's deeply committed to human rights law, social justice, and the role that women's rights play in uplifting the society. Her research and professional interests include access to justice, judicial reform, rule of law, economic justice and governance, criminal justice, and security sector reform. She's a strong advocate for the independence of constitutional bodies and respect for the rule of law through litigation and strategic engagement with key actors. She also speaks up for criminal justice reform through the campaign for the decriminalization of petty offenses. Is a program of deserving of a continental reflection. Aria?
Hello. Can everyone hear me?
Yes.
Great. Thank you very much, Mr. Ibe. So for the difference between petty and minor offenses, the things that these offenses criminalize. So petty offenses are offenses that criminalize social status. So you have offenses that would criminalize the day-to-day activities of people. And these things are seen as wrong because of the fact that they are poor, marginalized, what have you. And then we have minor offenses, which are things that are wrong, but are of a lesser degree. So an example would be stealing, but...
Hello?
Hello? Please, can you hear me?
Yes, we can hear you.
Right. So an example would be probably stealing a banana or offenses of a lesser degree that shouldn't warrant harsh offenses like incarceration.
Hello?
Hello?
Yeah.
Yes.
Are you done?
Yes, I am.
I think you probably forgot to tell us, why did CHRI decide to engage with this issue?
Right. So as Mina mentioned, the advocacy has been centered, rightly so, on petty offenses. We realize that there are some areas where minor offenses are enforced also in a very harsh manner. Yes, and because of the fact that the focus is on petty offenses, the fact that minor offenses also need the attention and also need to be declassified, and provision needs to be made for them in our laws, right, had sort of faded into the background. That's why we are here to refocus and have this conversation about the enforcement of minor offenses generally, we would have a look at the standards, what we would think is a good enforcement, and then we'll look at what we currently have, which is usually incarceration for most African countries that have harsh enforcement for minor offenses.
Yes, Stanley, we can hear.
Okay, excellent. Excellent. Thank you, Aria. Can I come to Luis? Good to see you, Luis.
Hi, Stanley. Good to see you too.
Yeah, I mean, I know that the Open Society Foundations has supported the campaign on the decriminalization of petty offenses pretty much since inception. Can you bring us up to speed on where things stand on that campaign?
Sure, and I think actually what Harriet just said was a very good introduction to that, because, you know, we've had this conversation right from the beginning of the campaign, which I think was about in 2014, around how we frame petty offences. And I think that Harriet is quite correct to say that there's a distinction between, you know, criminalising somebody for who they are and criminalising someone for what they've done. And so, you know, I think that was really where we started the conversation. But I think we've more and more realized that, you know, what this is really about is about an abuse of public security power, and that the power of the state often has a disproportionate impact on people who are marginalized, people who are poor. So it's not just about petty offenses. And the other thing is that we recognize that not everybody understands that term. But what I did want to say is that, you know, I think there's something very specific about the colonial legacy that underpins these laws. And so I think across Africa, the term petty offenses really comes from, you know, the fact that many of these laws, both the minor offenses and the petty offenses, as we call them, you know, come straight out of the British penal codes or the Francophone penal codes. And so this was something that really pulled us together. But Stanley, to answer your question, I think there's a lot that I could say about where the campaign is right now. But the first thing I want to say is that it remains strongly underpinned by the Learning from Africa. And I think that there's some seminal work that was done in Ghana, for example, the reports that were done in Ghana and in Sierra Leone and in Malawi and Nigeria, that really gave the impetus for the litigation that we saw coming out of the African courts and the African Court Advisory Opinion. And also just to note that the work that was done by campaign members, and I see a number of them on this call, to develop the principles on the decriminalization and declassification of petty offences, really created the springboard both for national level litigation and for the advisory opinion from the African Court. And I also just want to make reference to the very first case that we, and I'm saying we loosely, but I mean campaign members litigated, particularly Salk and Kriya in Malawi, overturning the Victorian era rogue and vagabond law, which can still be found across Africa. So I think that those were really, I just wanted to mention, and there are many, many other victories that we had in Africa, which really then were the impetus for what was our most recent global event in Stellenbosch at the beginning of, at the end of last year, where the campaign really became global. And so I think we had about, and others can correct me, but I think we had over 100 people from over 30 countries in Stellenbosch, all recognizing the, you know, the resonance of this issue around the abuse of public security power and the criminalization based on status, activism, poverty across the world. So we now have partners from the Caribbean, from Southeast Asia, from Southeast Asia, and from Africa, and a growing francophone subgroup that is growing, you know, both in North Africa, West Africa, and in the Francophone Caribbean. We've got a global litigation fund that's now been set up, and I won't go into too much detail now, but I just wanted to say there'll be opportunities to talk more about all of that, you know, during this conversation. But I just wanted to circle back to, you know, the opening remarks that were made, and I think it's a really, really good question that CHRI is posing, not just for you know, for our global work, but in Africa generally, about, you know, sort of broadening the scope of what we're trying to do and really understanding the power of the state to use its security apparatus to target people, either based on a drive for social control or political control. Thanks, Stanley.
Yeah, thanks, Luis. I wonder if you could say on the campaign a bit more. I mean, there's often a conversation about, what happens before and after. So is there a way to give us a sense about changes before and after? So I'm talking about before the declaration principles, before the advisory opinion. What sorts of changes? Do you have numbers in specific places across the continent?
Thanks, Stanley. I don't have numbers with me now, and I would be quoting incorrectly, but I do have some examples of the way that things have changed. So, but I first just want to caveat that by saying it's a term that the Americans on the call will understand, of the whack-a-mole effect, where you overturn one law and another one pops up in its place. So we're very conscious of that as well. But I do want to say that a lot of our colleagues have done research to see whether overturning rogue and vagabond laws or vagrancy laws has deterred the police from arresting people. And I think that there is evidence that certainly it hasn't stopped it, but it's made it a lot harder for the police to indiscriminately arrest people. But I wanted to give you a good example of a follow-up action that some of our partners have taken, and Stan, you'll know about this in Nigeria, but also colleagues that are with us from Malawi, is that, we had some successes in overturning some of the petty offence laws or the vagrancy laws. But what we saw was that the police were then using sweeping exercises to sweep up, people off the streets, for example, before a big meeting, or street children or homeless people, using other offences, so loitering laws, etc. And so I think what's been quite strategic is that both in Nigeria and in Malawi, there have been challenges to the sweeping laws themselves. So instead of going after the law, rather going after the practice, which I think is it's a kind of a way of bolstering overturning the law itself, but then also looking at ways in which you can also limit the ability of the police to arrest. We've also seen, and there are many examples, and I'm not going to list them all, where we've seen high-level political commitments to either the development of prosecutorial guidelines to guide states or compel magistrates or judges to consider diversion or alternative sentencing, or to give an explanation for why they've proceeded with the prosecution. I think that's really interesting. Or alternatively, to remove certain offences from the statute. So I think that, I've been saying, there's so much that's been done in Africa, and there's really an interest in capturing those lessons in a way that's understandable. And we are working towards that. And one other thing that I wanted to mention, which is a new development, is that we're exploring an idea, and it's very much an idea now, around potentially developing what we're calling a judicial bench book, which will give guidance to judges and to courts on how to manage both minor offences and petty offences. And so, that's in progress. But I think it will. Why I wanted to raise this in this meeting is that in order to do something like that, it would be really good to capture the lessons and the learning that's coming from countries across the continent that are doing incredibly innovative work. And then I wanted to just make one more mention, Stanley, before I stop. And I always say this to you when I see you, is that outside of the campaign, there's obviously been so much work that's been done on this. And one of the things that always springs to mind for me is the work that's been done in Nigeria on the duty solicitor scheme. Because really often, we'll see people being arrested in the way that I've described, who shouldn't have been arrested at all, but have no access to a lawyer, have no access to a paralegal in that early stage of the process. And so, Nigeria has really been incredibly innovative, because we don't see this in many other places, trying to make sure that they can provide access to lawyers at that really, really early stage, where it's crucial that, people should be released and not, find themselves in the criminal justice system and unable to extricate themselves because they're poor and they don't have the money to pay bail or pay a bribe. So anyway, there's lots of learning, not coming just from us, and I think that capturing it will be a really interesting exercise.
Thanks, Luis. If I can come to Edmund, I mean, Luis makes the very important point that sometimes it's a bit tricky making the move from just changing laws to practice that reflects the changes in laws. And we could say the same about litigation.
Yeah.
So how effective do you think litigation has been on this subject from your experience? I know IHRDA has done quite a lot of litigation on the subject. So what has the experience been like? Have you seen changes on the ground?
Yes, thank you very much, Stanley, and a warm good afternoon to my dear colleagues and everyone on this call. I think in even doing a bit of research on this subject, starting from outside the continent before we come in, I actually discovered an old decision of the Irish Supreme Court in the case of Melling versus Omar Noma. In which the Irish Supreme Court had to determine the question of what a minor offense is. And the quick background to this case was the fact that the plaintiff who had brought the matter, one Mr. Melling, had been charged with smuggling butter into the country. And his central argument was that he was brought before a district court by the Commissioner of Internal Revenue, of course, and offer Mr. Omar Noma, who was representing the commissioner, also the context of the relevant law that made smuggling butter a crime, but also under the Irish Constitution then. And this is the decision given in 1963. But what made Mr. Melling a bit angry was the fact that if it was considered a minor offense, then he was tried summarily before a district court and fined. His argument was that given the nature of the issues, it should have been tried by jury before a high court. So this was essentially the issue. Okay, is this a minor offense or a major offense, as it were, that should go? And the Supreme Court, in determining the matter, came to the conclusion that you have to look at the issue from essentially 4 main points, which are the basic principles that at least all criminal lawyers or people who work in the criminal justice system deal with. So the issue of the gravity of the punishment, what was the mental state of the person who was committing the crime, what is the intent of the law, looking broadly at what was sought to be criminalized. So in the final analysis, the court was of the view that Mr. Melling had a point. So definitely it is a question that we would have to engage. And I think that decision provides a very good background and thinking as to the fact that if people raise this issue of us having to determine the status of certain offenses, it is good. Now, coming into the African continent, we have seen the Gwanda case from Malawi, in which the Malawian court also struck down the vagrancy laws of Malawi. I think Luis made reference to the work being done in Malawi. Then we've also seen the very seminal decision which the African court gave in the advisory opinion that was sought from it by the Pan-African Lawyers Union, in which the court actually determined that the existence of these laws and their application in most African countries actually violates the African Charter on Human and People's Rights and other laws. More recently, IHRDA and Advocate Sierra Leone have filed another case before the ECOWAS court, challenging the loitering laws of Sierra Leone. And the central argument there is that this also, in its application, unfairly targets the poor and unfairly targets women. And we actually demonstrated to the court that principally women who are engaging in commercial sex work are the ones who are being picked up by the police on account of loitering. And actually, in some instances, the police end up even raping them. Unfortunately, we haven't heard back from the ECOWAS court. We are still waiting for a hearing date. But all in all, at least we have seen at the continental level the emphatic statement made by the African court in its advisory opinion, clearly that these laws, though speaking in the context of petty offenses, these laws are no longer things that should be sitting on our statute books. And then, of course, also the bold steps taken by the courts in Malawi to also strike down their laws. And we hope that the ECOWAS court decision will also provide further legal authority for us to continue the advocacy work. But I think that decision also by the Irish Supreme Court, in which they juggled with the issue and the judges acknowledging that it is indeed a difficult question, is one that should actually then afford us the opportunity as African advocates to push our governments to re-look at our criminal laws and break these down into the proper, you could say, categories of crime that should be dealt with.
Yeah, thanks, Edmond. So because you raised the African Court Advisory Opinion, I think it's fair to ask how you might respond to a state that says, you know what, at best, that is an advisory opinion on one hand. Secondly, even if it were binding, that will only cover 34, I think the last time I checked, maybe a little more, states that have ratified the African Court Protocol. You know that the states that allow NGO and individual access to the court is much less. So how would you respond to that?
Right.
Secondly, on ECOWAS court, this case you're referring to appears to be dragging quite a bit. I don't know if I'm mixing up the timeline. Well, can you give us a sense how much?
Right. Yes. So quickly from the second one, then I go to
the case has been in it. Okay,
yes.
How much longer will we have to wait?
Exactly. We filed this case in 2002, last year, 2022. I was just checking from our records when we filed this case, but it was somewhere, I believe, around May that we filed this case. And so it's really unfortunate. For the ECOWAS court, we would have expected much quicker action. I think Sierra Leone has responded, but we are still waiting for a hearing date. What we do, at least in IHRD occasionally, is to write to the registry of the court, and perhaps for the record to indicate that now our former executive director is a registrar in the court. So we definitely have to follow up and at least get a hearing of this matter within the coming year. So I would project that, but within 2024, we should be seeing a decision from the ECOWAS court on this matter. Now to the first question, yes, we filed this around 4th May last year, 2020. The advice for international lawyers and even lawyers at the domestic level who would work with this, the immediate response would be that it is persuasive. But I think we've also seen that there are opportunities for us to work strategically with the broader African human rights system. And so how do we engage, for instance, the work of the special mechanisms? With this decision coming, how do we push this into the country missions that are being done? Much as some of these decisions are not binding, we are also seeing in a few cases where states are responding. So I'll just give one example. Just recently, in a case against Ghana that we filed together with an investigative journalist in Ghana. In this case, though not on petty offenses, but on the right of girls to go to school, which is being hampered because of certain cultural practices. So when women, girls are, news is that the government has actually contacted us to take them to the place where the violations are occurring with a view to actually doing something about the issue. The committee has issued its decision on admissibility, a very well-written decision on admissibility, which is good from the treaty body's perspective, that they are now writing reasoned admissibility decisions. And the government has responded. So I think much as we would not get a lot of traction from states, there are few states whose actions indicate that they are worried by such decisions. So I would think that we should not rest on our oars, but use the advisory opinion as much as possible in our advocacy.
Great, thanks, Edmund. And speaking about resting on our oars, Julie, good to see you. I see you've done quite some work on the guidelines, the advisory decision in Kenya, elsewhere. Could you tell us a bit about your advocacy?
Thank you very much. My name is Julie Wayamadeka, as you have been informed. I work in ICJ Kenya, which is a member of the National Criminal Justice Committee of the National Council and Administration of Justice. So the National Council and Administration of Justice is an institution in Kenya, which is chaired by the Chief Justice, which brings together all justice actors working on the issue of justice, access to justice for all persons in Kenya. And within that bigger framework, they created the Criminal Justice Committee. Now, the Criminal Justice Committee was created in 2017, and that was actually as a result of the fact that ICJ Kenya, Legal Resources Foundation, the Rodi Kenya, and the National Council had actually undertaken research to the effect that a lot of the persons who are incarcerated within the prison system were actually persons who are charged with petty or minor offenses. This document is referred to as the National Council and Administration of Justice Criminal Justice Audit. So this audit revealed that you have 70% of persons who have been incarcerated within the prison setup, be it on pre-trial or post-trial detention, having committed petty or minor offenses. With that said, we then went forward to begin a conversation around how then do we decriminalize petty offenses, because indeed the criminal justice system was focusing quite a bit on the issue of handling minor and petty offenders. So guided by the principles on decriminalization of petty offenses in Africa, and also the advisory that had been filed, we used that to leverage Kenya to push for these guidelines. So what we then developed were guidelines that are very specific to Kenya's context on the management of petty offenders. And these guidelines were very important because as ICJ Kenya, working in the campaign has been, that we are facing in Kenya are actually African problems. You would go to Malawi, you go to Ghana, you go to South Africa, and the same issues are arising. Persons who are before the criminal justice system are persons who are poor, vulnerable, and are actually criminalized because of life-sustaining activity. And this is in regards to petty offenders, life-sustaining activities such as hawking, street vending, outing, or ideally being unwanted, so ideally homelessness. So with the amount of research we had on the African continent, it was very easy for us to persuade the National Criminal Justice Committee to be able to consider tailor-making guidelines around petty offenses. Now, another thing that came about that actually amplified the movement around petty offenses was actually the COVID-19 pandemic system, because you'd have a lot of and cannot be held in those conditions of detention because of, unfortunately, spread of the virus. And this was actually important for us because we were able to leverage on the fact that the justice system responded well and actually gave a moratorium, more or less, on arrest and detention of petty offenses, for us to say that it is possible as a country for us to look at alternative ways of dealing with minor and petty offenses instead of putting them through the criminal justice system. So coupled with that, we developed the guidelines. But I must say that there are other guidelines in this country that have actually contributed to, I would say, a decreased number of persons behind bars, behind detention facilities. The Office of the Director of Public Prosecution in our country developed the diversion policy guidelines. The diversion policy guidelines were meant to be used by the prosecutors to be able to identify cases that don't necessarily have to go through the criminal justice process and refer them to various entities. For example, the probation and aftercare services, medical treatment, or also a community setup that could actually rehabilitate the person. So that is one way of looking at diversion. And this is pre-joining the criminal justice system. Now, looking at post-joining the criminal justice system, the Office of the Director of Public Prosecution then again created the plea bargaining guidelines. Now, the plea bargaining guidelines are ideally supposed to be used whereby a person who unfortunately is charged with a minor offense can actually bargain for a lesser sentence in regards to either giving insurance. That was built by policymakers in order to ensure that we do have a lot of minor offenders behind bars. The other thing that I would say has been very pivotal is the work of the National Committee on Community Service Standing Orders. And this committee has actually allowed for a lot of releases periodically of persons who are incarcerated for minor offenses. And if I was to give statistics around that, because we do have them, one thing we're happy about is periodically, we do have a lot of persons being released. So in 2022, we had a total of 3,000 persons released at the beginning of the year, 6,000 people released in the middle of the year, and at the end of the year, we had another 5,000 people released. Last month, the president released 2,942 petty offenders and 2,117 persons who had less than 6 months to complete their sentences. And indeed, what we are seeing is there is an appreciation of the Mandela rules in our country, appreciation of the Ouagadougou Plan and Action Plan, and also the appreciation of the principles on the decriminalization of petty offenses within Africa, which now led to the guidelines that I speak of on the management of petty offenders. So we have been able to leverage on the tools that have been developed by the network, by the campaign, to be able to run this campaign. Another important thing that I would add to this conversation is the fact that this campaign has not only been an ICJ Kenya campaign, but an African campaign, has also allowed us to seize that and ensure that it is not just one organization pushing an agenda, and also push our policymakers to realize that indeed they will be left behind if they do not act. So I'm happy to report that even as we are having this conversation, we have already looked at our penal code, at our criminal procedure code, and we are now going to be engaging with Parliament with a view to having a wholesome review of the petty offenses and some minor offenses. But as Louise said at the beginning of her remarks, one thing we are cognizant of is, unfortunately, we have a type of a whack-a-mole mentality whereby we can decriminalize certain offenses, but they will be reintroduced through another mechanism. So as the continent knows, in the months between March and August, we had protests around our system of governance, and it was led by the opposition political party. And we found that a lot of people during that period were arrested for exercising their right to protest. And we saw a way in which these petty offenders, the same way that we treat minor offenders and petty offenders was being treated to persons who are protesting. So we are seeing certain laws being used to create short-term imprisonments and short-term incarceration times, which ideally was not the case and is not envisioned, even when you look at the principles of the decriminalization of petty offenses. These are not the offenses that we spotlighted. However, policing and policing powers are using other provisions to enforce and create systems that mimic the petty offenses systems. So that is how we have been able as ICJ Kenya to leverage on the movement of the African continent and the principles, as well as the advisory opinion. Thank you, Ibe.
Thank you, Julie. So 2 questions come to mind fairly quickly. The question about releases and the tendency to have more arrests as you release. So have you looked at, as ICJ Kenya looked at the intersection between this, very impressive releases and the number of arrests that are made? And then the second question relates to the point you made just before you closed. And I think Louise echoed that same point, the idea that the campaign is focused on very specific offenses. And, the states have a way of, essentially repackaging these offenses in another way. So how do you catch up, or how do you cope with the changes that happen to these laws in your own context?
Thank you. In terms of the releases vis-a-vis the arrests, unfortunately, that is something that we are cognizant of, and we are trying our level best to ensure that policy direction does influence the work of the police and policing powers, because whereas we could give legal representation to every single person, and we do try as much as possible to give legal representation to persons who are arrested for exercising the right to protest, for example, we note that we need more policy interventions and legislative action to relook the laws, to look at the laws that actually criminalize certain activity. For example, I'll give an example of what was used to arrest certain persons, which was the Computer Cybercrimes and Misuse Act of Kenya, as well as the Public Order Management Act of Kenya. These are laws that ideally govern the civic space arena. We're talking about use of technology, we're talking about peaceful protests, but they are now being used to prevent or to take away the liberty of a person to exercise certain freedoms, as well as their liberty to be free in the society. They're actually reining in on that. So we have been looking at engaging policymakers to look at the loopholes within the certain laws, but also strategic interest litigation. ICJ has been involved in certain strategic interest litigation that has pushed for this. For example, when the Public Order Management Act was being used, unfortunately, to discriminate against persons who are exercising their right to protest, we raised a caution that indeed it is time to relook at the entire law with a view to amend it to protect the right to protest, but also to sensitize police officers. And I think a key thing around this campaign has also been to reach out to duty bearers for them to appreciate what their actions are doing to the general community and to the fabric of the nation. So we have been trying to sensitize police officers around why what they're doing is an excess and an abuse of their laws. But we are getting there. I will say we are getting there. So in terms of the guidelines on the management of petty offenses, we are rolling out an elaborate sensitization campaign, which will target duty bearers, but also the public. In terms of the national sentencing guidelines, which have just been released, we are seeing the judiciary is open to conversation around non-custodial sentences. So even as you arrest the people, then they are brought before the courts, they are actually released. So after a while, the police officers get a cue that indeed you will not be able to get away with arresting persons and bringing them to court expecting lengthy sentences. The courts are aware that this is a person who ought not to be before the court. So they will defer that matter and actually release the person. Now, what we are trying to do is ensure that these people do not have to go through the criminal justice process because of its inhumane nature generally. So that is the way we are approaching it. But indeed, it is a challenge because sometimes a lot of people are arrested and you really cannot spread your resources that widely.
Thank you, Julie. If we can get back to the question of declassification. So for somebody who doesn't know exactly what this means, what exactly is the proposal for declassification? How might it strengthen the criminal justice system? Can we begin with Haria? Do you have any comments on this?
Right.
Haria?
Hi. Please, can you hear me?
Yes.
Great. So on declassification, a lot of things have come up. We've seen examples from other countries where there are things like probation, there are non-custodial sentences, there are fines, there are rehabilitation methods of dealing with these minor offenses. In most countries, we've seen that they have the fine system, but the default is incarceration. Now, if the offense is usually, if the actions are usually taken by poor people who will not be able to pay these fines, that's essentially straight to incarceration because the default of a fine is going to prison. So we would need alternatives that don't lead back to prison, like fines, probation, yes, things along those lines.
Okay, so I've heard state officials say to me, you know what, this all sounds great, but the reality in many of our countries is that we don't have a proper ID system. And so really, if we ask people to do community sentence, for instance, it's sometimes difficult to track them. How would you respond to this?
Right. I would say that a lot of money goes from state funds into incarcerating these offenses. If you look at the margin of the offense, the value of the things that, for instance, in the event of stealing, as against what the state has to spend per person a day, right? If we are able to divert those funds and use them to create proper systems for us, for these kind of reforms to work, I think that would be a much better way to look at these things. Most duty bearers and most stakeholders use this excuse, and they say that we don't have the systems to implement these very great ideas that you are bringing forth. But that is on the state, right? A lot of money is being used for other things that may not directly serve the purpose of the people, right? If we are able to divert funds from incarcerating these minor offenses into setting up the proper structures, I think that we can start small. You start step by step. You look at the case by case situation of every country, right? We look at what we have, and then we set up the little structures, and then we add to them. And I'm sure that if we look at it from this angle, a lot of the states will be able to put out the proper structures and eventually implement non-custodial sentencing for minor offenses.
Yeah, Luis. There's some noise in the background. Luis.
Hello, Stanley. Yes, I'm listening. Hi.
Yeah. So the question of incentive, I mean, that's the last point Haria and I were talking about. And the real question is, why should states invest in criminal justice reform? And what exactly would this declassification do to strengthen the criminal justice systems across the continent?
Thanks. And I was just listening to Ari, and I was thinking about, I've just come back from Thailand, from the Open Government Partnership Summit, and the Ghanaian delegation, was doing a presentation on all of the things that the administration has done. And, it just made me think about how all of these functions of government are connected to each other. And one of the things that they were talking about was, using technology to, and there is a point to what I'm saying, mark streets and houses and numbers, and to be able to, find and locate people. And I think that there are lots of different functions for things like this, and having a functional government that is, serving its citizens, because often, as others have pointed out, when we say that, we can't implement some of these non-custodial sanctions, etc., it's because we can't find people and they're going to abscond and etc. So I think that there's a whole, raft of efforts that governments have to take to create some order and to create systems that provide services to their citizens that impact not only, the broader public, but also people who find themselves in the criminal justice system. So it was just interesting to me to hear, the presentation by the Ghanaian delegation. And obviously, some of it is, perhaps overstated, some of it understated, but it was really good to hear that there was some of this initiative. And so on the question of incentives, Stanley, I think that, there are lots of arguments that one could make. And I think those of us coming from a human rights perspective, obviously, make arguments that are not necessarily easy to sell around, human rights and protections, etc., etc. But I think when you're speaking to government officials, there is, a fairly strong interest in, making sure that prisons are not overcrowded, that, criminal justice institutions and services are not overstretched. And I think that there's a very compelling argument to be made for the fact, and I think Julie alluded to this, the amount of resources that are going towards, arresting, prosecuting, sentencing, and incarcerating people who've really done, very little to influence public safety, or, to the detriment of public safety. So, I think that if one had to use an economic argument, one could do that fairly easily. I think there's also, one of the things that I think if you have to ask people what they want, from their government, it's usually, in addition to sort of economic stability, and social safety nets, it's peace and security and safety. So I think that, one of the arguments made in Kenya when, these guidelines were being launched, was that, you know, with all of the attention that's been given to petty offences, there are very little resources left to deal with, you know, crimes like rape, robbery, and murder. And those are the ones that really are, you know, a risk to public safety. So I think, you know, I think there's some very definite arguments that can be made for why we should be Tim's often wanting, you know, some kind of closure around violent offences. We have very little forensic capacity in our police services, for example. And so I think reallocating resources to things that matter to people instead of, you know, spending almost all of our time prosecuting and re-prosecuting and finding people who can't afford to pay the fines. And I just wanted to make another point around this declassification and alternative sentencing and non-custodial sentencing. I think one of the things we have to remember is that many of our post-colonial penal codes do actually provide for all of the things that we're talking about around community service, around plea bargaining or plea and sentence agreements. It's not that they're not there. It's that the arguments that the other speakers have put forward around the fact that they're not being implemented or they're difficult to implement are often the reason why we're not seeing them rolled out. So I think part of what we need to be doing, you know, if we want to be making arguments for implementation, is to, you know, understand what will be required to implement them. And then, of course, to look for the gaps in the law and make sure that there's law reform. You know, I think some countries, the colonial laws are still very much present, but there are others where, you know, I think there is very specific reference to alternative sentencing, diversion, etc. It's just, you know, always seen as the easy excuse to say, well, we can't implement this for the reasons you gave, Stanley, around, you know, not being able to locate people, people are going to abscond, audit, etc. So I think that you know, we've got to come at this from many angles.
Hello.
Hi, I'm here. Stanley?
Yeah, I think he's frozen.
A very wise look on his face.
Hello, Stanley, are you there?
Yeah.
He's muted. Okay.
Oh, you are back. Okay.
Hello. Yeah. My political enemies managed to lock me out, but I'm back. Thanks, Louise. I mean, you made a very interesting point when you asked what people want of their government, and I'm wondering if you were to, I don't know if that research exists anywhere, but if you were to ask on the continent, at least in countries where you work, do you have a sense of how much of a priority this topic of discussion would be?
Are you asking me, Stanley? Yes?
Did you hear me?
I did. So this is just, I'm just going to respond anecdotally because obviously I haven't asked people what they want. But I think that, you know, I've been working on criminal justice for decades now. And I think there are many others on this call that have been doing the same. And we know how difficult it is to get the issue of criminal justice onto the agenda, other than when it's, you know, on the side of, and I think some people have made these comments in the, you know, in the chat around, you know, high profile crimes and referendums and whether to bring back the death penalty. And, you know, so I think that people who are, you know, on the side of ripping up support for punitive criminal justice reforms, they find it fairly easy to get this as a, you know, onto their, you know, as a talking point on their, in their campaigning for re-election. And, you know, the concern for me obviously is, and for all of us, you know, we're seeing the rise of authoritarianism around the world, and we've seen how easy it is to, you know, create fear and suspicion and othering and, you know, using, as I said before, you know, the criminal justice and security architecture to advance an agenda and to create the perception that this is what's going to keep people safe. So I think that what we need to be doing in the space that we work is really sharpen our arguments around why why a punitive criminal justice system doesn't necessarily keep us safe. And I know that there is ample research that demonstrates this. I think we don't need to redo that. I think it's been demonstrated over and over again that punitive measures do not bring down levels of crime. The death penalty and life without parole, etc., have no impact on levels of crime. I think as I say, we don't need to be doing that again. But I think we need to be sharpening our arguments for why it's important that we have equity, we have equal access. People have access to legal aid, people have access to lawyers, and what that means for, the way we live with each other and the way that societies function. But the evidence is there. We just need to be accessing it and, continuing to build it, I think.
Yeah, I hope everyone else heard Luis. I got cut off at some.
Yes, brilliant. Fantastic.
What people interesting question. Now we're going to try and wrap up this part of the conversation so that our colleagues on this conversation can also chime in. And I'm wondering if we could begin to think about concrete proposals now. If it was up to you to turn the tide on petty or minor offenses, whatever name you call them in Africa, what would be your top 3 proposals for reform and why? Can I start with Edmund?
Thank you very much, Stanley. So quick one would be investment in research for our African countries. And research to understand, it's already there. And I think the support of civil society organizations is overwhelming. If they ask, we would. There is already some out there in the field. But what am I saying what I mean by research? To understand perhaps the specific idiosyncrasies in our society and how things are changing. In the Gambia, as we speak today, the top headline from yesterday was the shooting of 2 police officers dead and 1 who's been left in critical condition. For those who know the Gambia, this is big news. How did somebody get a gun? I mean, shooting of that nature and shot 2 police officers, in fact, 3 of them, shot 2 in broad daylight and ran away to Casamance, but he's been arrested. So for the Gambia, for instance, how do you understand the changing society in the context of this new democratic transition and understand how you approach crime? Just related to this issue, 3 women were convicted for conducting FGM and fined roughly about $300 each. An influential imam has gone to pay the money off for them, and a call has begun to repeal the law criminalizing FGM. So I think when you have such contrasting issues occurring, then you need to understand the society's dynamics. Then, of course, the economic and social context in which crime is occurring is also something we have to look at. So I think it is a national call to begin to see the economic cost of not reforming the criminal justice system to the society at large. And that would be my key recommendation to our governments. Let's begin to have the hard conversation and put resources to understanding it before we reclassify and actually increase punishments here and there. Thank you.
So that would be 1. Do you have 2 more? Or that's
okay. You asked me for 2 more. I think quickly, test cases, let us use the courts and get the courts to speak emphatically in specific cases like happened in Malawi, like have happened of course, at the regional level, which would have an impact domestically. And then lastly, I think the initiatives that Julie raised happening in Kenya, using those other allied agencies in the criminal justice system, those initiatives, I think I would second those as well. Thank you.
Yeah, thanks, Edmund. And I'm wondering, Julie, I'm going to come to you on the same question, whether, it could be early days yet, But I'm wondering if your organization and perhaps others you're working with that considering just documenting the very important work you're doing in this field. If you could give us some feedback on that in addition to the same question I asked, your top 3 proposals for reform and why?
Thank you. All the work that we have been doing around the decriminalization movement is on our website and also on the Africa website, the decriminalization website. We have now moved from decriminalization of petty offenses. We are now talking about decriminalization of poverty, status, and activism, because we saw the need to broaden the campaign. So in case someone is looking for decriminalization of petty offenses, the petty offenses website, it is still there, but we're moving to another one. So please check the other one. But in regards to my top 3 things that I would recommend, one is to invest in diversion policies, invest in plea bargaining policies, invest in policies that ensure that persons do not get into the criminal justice system. I will speak to alternative justice systems policy, which I also spearhead. The idea is that as African countries, we have been able to resolve disputes in the community with elders, with church leaders, with our local chiefs, even with our religious leaders. We have been able to ensure that there is community harmony and restorative justice within the community. And some of these issues have been resolved there and do not need to go to the criminal justice system. So when we went into this particular agenda, we asked ourselves why, according to the data, the mainstream judiciary gets almost 8% of cases across the board. So we asked ourselves, where are the other 92 cases going? And some of them were being settled through arbitration, mediation, and all the other forms of alternative systems, but ADR systems that are formally recognized. But we noted that a lot of issues are resolved at the grassroots level with alternative justice actors. So we decided to invest in these policies. And as we are going around the country polarizing the policy and also harnessing data, we find that a lot of people really do not come to the criminal justice system, do not report issues to the mainstream system because they have their way of resolving disputes. So I would challenge other countries to look at these systems and see whether they work for their countries and amplify them. The other thing is, because they are African-grown systems, they take into questions peculiarities that we know, so that it is justice for us as we know it. And I think that is very important. The other challenge that I will say in this system, so that I cannot say it's a beautiful system that has no ills, is the fact that there are some harmful traditional practices that still go on. So even as countries consider championing alternative justice systems, it is important that the people championing this are cognizant of the potential historical harms that have happened to women and persons living with disabilities within the community, to ensure that even as you promote these policies, they do not derogate persons' human rights. So that is the first one. Investment in various policies to ensure persons do not come to the criminal justice system. But secondly, I think it's important to invest in community orders, main systems. So for us, we have the national community orders. I do not know whether all countries have that. And I think it's important to have these systems in place, because when people are when people are given non-custodial sentences, they can't be able to actually actualize those sentences that they have been given, because there is a system that ensures that these sentences are actually done and are meaningfully done, because the idea of non-custodial sentences is not to dehumanize the person, but to ensure the community appreciates that the person did a thing that violated the community, and through this action, they have atoned for it. So the idea is to ensure that there's a system there. So ensure that governments actually create community service systems, ensure that there's accountability, ensure that they are humane, that they do not perpetuate cruel and inhumane treatment, and ensure that they are inculcated in terms of being a system and a recognized system of sentencing. Because what we are seeing in Africa is an over-reliance of incarceration. And we need to appreciate that there are various ways to pass down a sentence. You could consider non-custodial sentences, such as giving a fine, giving a caution, giving a discharge of the charge before you, sentencing a person to community service, Also sending a person to medical treatment because a person might have committed an act and it was because they were not well. And we need to be human about how we do things. So ensuring that there are various opportunities for diverse sentences that are there in the criminal justice system to ensure that the default that is normally incarceration is not the one that a lot of judicial officers pivot to. The third one would be legal reform. I think it's important that as actors within the space, and particularly for civil society organizations or persons who work very closely with duty bearers, is to ensure that you unpack the various legislations that have actually been overutilized to criminalize poor and vulnerable persons who have committed minor or petty offenses, and ensure that once you collect this body of resource as legislations, that you then champion for their amendment. And not only are you looking at their amendment, but the implementation of the newer reformed laws, so that you do not stop at just the repeal of the laws, but you look at what is then substituted and ensure that it does meet the human rights threshold, and purposefully engage the duty bearers to see whether what you have then reformed is being utilized and what more can you do. I agree completely that it's imperative that we move to the courts. Sometimes it's easier to deem something unconstitutional by moving to the courts. And I think once we engage the courts robustly through litigation, but also through engagement by capacity building, training, and partnership, you might be able to appreciate the reasons as to why certain sentences are meted out, and now work with the courts to ensure that they can relook and give a different perspective when they're dealing with certain people. I am happy when I engage certain judicial officers who tell me that after we train them on petty offenses and the various violations that people go through in terms of them being coerced to give a bribe, in terms of them engaging with law enforcement officers who subject them to torture, and then coming to court and being given a fine that they cannot afford, and therefore, to some extent, forfeiting the wares that they already had, or in other instances, once they are arrested, their wares are confiscated and given away. And this is someone's livelihood. They then say that they cannot be a part of a system that actually perpetuates an injustice. And then when a person such as a hawker comes before the court, they're able to inquire and ask whether this person's wares have been returned, whether this person has the requisite means to get and actually meet the fine that they have been given. So it becomes an inquisitorial process and not the court speaking to this person, but ensuring that there is a human face to it. So that would be my quick responses. But I think every country invests in proper bail and bond policies. Also ensure that even as you move to fines as opposed to custodial sentence, to then defer the person back to the sentence, ensure that a bond or a bail term can secure their release and ensure that they enjoy their freedom for liberty, as opposed to be a tool to ensure that the person stays longer under pretrial detention because they cannot afford the bail or bond terms. So those would be my quick ones, but I'm happy to give more if time allows after the interactive session with the panelists. Thank you.
Okay, so talking about time, I'm going to try, we need to try and speed this up so we can get some 30 minutes at the end for the audience to participate. But I wonder if you could just throw this in the basket for at some point when you provide your concluding remarks. One of the big questions always about plea bargaining is, oh no, this is about the people who can afford to do plea bargaining. The poor don't get a bite at the cherry, essentially. So how would you respond to that? But let's leave that until the very end. Haria Luis, if we can take max 3 minutes to just highlight 3 top proposals we might have from. I'll start with Haria. Haria?
Hi. So my top 3 would be for us to actually do the work that is required for us to implement these reforms. I feel like a lot of the duty bearers pay a lot of lip service. It's very easy for you to sign these treaties and tell people that this is what you are doing, but a lot more work needs to go into how these things are going to be implemented. So as Mr. Foley mentioned, actual research systems and what a lot of these really, really high standards and see us for what we really are, puts in the work to ensure that the laws are applying to everybody equally and nobody is left behind. Thank you.
Yeah, thanks, Harry. I wonder if you could also drop this in your basket at some point. So the question about rehabilitation, obviously high priority. So how do we create incentive for governments to actually prioritize that point? Luis?
So I think the previous speakers have listed a lot of really important doors. I think Julie gave a really good list. And I just made a note of 3 things. They're fairly specific, but I think, we've got to start somewhere, I was thinking. So the one thing I was thinking about around litigation is that the colonial era laws really are low-hanging fruit, because many of those laws are incredibly broad and incredibly vague, and we have really good language in the advisory opinion, which would help us to overturn some of those. And I think chipping away at those discriminatory legal frameworks is a helpful start. And so one thing really quickly, the rogue and vagabond law is still actively enforced in about 7 or 8 countries in Africa, with exactly the same wording that was used in Malawi. It was successfully challenged using those same arguments in Uganda. I think that there's a case that's been filed in Nigeria. So I have this vision of a domino effect across 7 or 8 countries where we get rid of rogue and vagabond for once and for all. So that's a kind of an achievable target. And then just on top of that is just, if we want to dream, there's also the offence of vagabondage, which I think is in about 14 or 15 Francophone countries in Africa. Very similar language, but coming from the French and in the civil law system. So I would say, why not have a look and see whether we can't challenge that as well. So that's number 1. Number 2, and we haven't spoken about this a lot, I would think, there's a lot more that we can do to change hearts and minds and public opinion, because I think public opinion is bringing in, governments that are willing to, create these punitive systems. So really using comms and advocacy, strategic advocacy to, shift the debate. And I think there's some excellent materials that have been done through the campaign. And we're busy, for example, doing a documentary. One of our partners is doing a documentary in Sierra Leone, which I think is going to be incredibly powerful. And I know that there are many, many other ways in which people are using comms effectively to change the message around the need for these laws. And then the final point I would make, in addition to all of our work on the continent, is to really think about trans-regional solidarity, because as I mentioned at the beginning, there are many countries in the Caribbean and in South Asia and in Southeast Asia that are sitting with almost identical penal codes and almost identical problems, and already taking lessons from the continent, and from the advisory opinion, and I think that we can learn from them as well. One example is that, I think Julie was talking about, the criminalization of expression, association, and assembly. And, one of the laws that we're seeing across the board in penal codes that come from former colonies is the offence of sedition. And where it has been gotten rid of, people are using new cyber laws. So I think there's much that can be learned from India and from Pakistan, for example, and Malaysia on attempts to overturn those laws. So I just wanted to encourage people to, engage and think about that trans-regional solidarity as well. Thanks, Danny.
Yeah, thanks, Luis. That's a great place to turn it over to the audience. But before I do that, you made an important point about changing hearts and minds. So if you can think about how we do that and how we measure when that is done, that would be helpful for later. Can I turn this over to the audience? Are there any questions? Any comments? Anybody?
Finally, there are a few in the message box, so you can check them out.
Okay. Please just read them out if you can see. I'm trying to go through the questions if I see any.
Okay. So there's one from Husseini Yakubu.
For those who are looking for the website, Luis has put it out there. Yeah.
There's a suggestion
Please go
from
ahead.
Husseini Yakubu, and it reads, I suggest a strong advocacy for the repeal of Amendment or amendments of Chapter 8, Public Nuisance in the Criminal Offences Act of Ghana, since there is still the discretion for judges to impose custodial sentences on convicted persons. The Plea Bargaining Act passed by Ghana is a good start in addressing this issue, but there is the need for education to the public for accused persons to take advantage of the act. My commendations to the various human rights groups in Ghana for the behind-the-scenes actions and support in this endeavor. ASP Yakubu Fuseni, CID, Ghana Police Headquarters.
Thank you, ASP. Haria, Edmond, Mina, anyone else be helpful to get your feedback on that, if that's possible.
Yes, thank you very much, Stanley. If I can chip in. Yes, ASP, thank you very much for that point. Interestingly, though, the Plea Bargaining Act has started with a high-profile case, and I think it was Luis who indicated at some point that often what gets the attention of sort of criminal justice reform or discussions around the criminal justice system are high-profile political cases or, issues that have a political twist to it. And so I think the education, as far as media also comes in here. Much as the media would place emphasis on such stories, I think also where we have situations where the Plea Bargaining Act could be used for persons who really need it, we should also emphasize. And Yakubu, thank you very much for bringing up that point. Stanley, I'll just quickly add that another area we could look at is the training of lawyers. And I was just thinking to those of us who teach criminal law, criminal procedure, what is the orientation we are giving up and coming lawyers, even from law school, who are going to be judges someday? Perhaps for those in legal education, we should look at those new disciples, as it were, coming into the field and begin to reorient their minds from the law just being out to punish people with no remorse whatsoever or no consideration of their humanity, to sort of a more anthropological and human-centered understanding of criminal justice and criminal law. Thank you.
Yeah, so because you raised that, I found it very interesting, at least here in Nigeria, to find that until very recently, human rights curriculum was essentially Nigeria and then UN. And I started asking what happened to Africa. So it will be useful. I don't know what, and it will be interesting to get some feedback around the table as to what the situation is in your countries. How much of a priority is the African regional human rights system in your different legal education curriculum? Does Haria or Mina have any more points to make on that other topic?
Thank you, Stanley. On the superintendent's issue on the plea bargaining, I believe that the problem, he's encouraging us to do advocacy, which is a good point, because a lot of people don't even know that the law exists. I mean, there was a bit of noise around it when it was passed, and the understanding of that law. So if we are going to make any headway, in our part of the world, is education. If people understand and imbibe in it, then they can use it. Unfortunately, the people who actually need it do not understand. Like the whole high-profile case that Edmond was talking about. Obviously, the person has a lawyer, and so the lawyer would advise on that. But those who actually need this law would not have anybody advising them on it, and that creates a problem. So I think the civil society, our work has been cut out for us. We need to up our game, and like Edmond said, the media, because for the advocacy to go far, journalists need to understand the law themselves to be able to do proper education on it. Because at the end of the day, you as a CSO, what platform that you have little bits of platform, but they have the space. So they actually create the content for whatever they are doing. So it's a good point to engage the media and sell the idea and how good that would help to decongest our prisons. Because like we said, governments are more interested in how prisons are going to be decongested without they having to answer to the public on the fact that criminals are running around the streets. So that would be my take on it. So ASP, we thank you for your comment, and we hope that the police administration would also support in the work that we do, because sometimes certain policemen also create problems for civil society who work in that space because of the mentality of a lot of indigents themselves. People think that the moment you are accused of a crime, you must have done it. So even if a policeman wants to help, it's like you collected a bribe, and that is what is going on. So thank you for your point, and we'll see how it goes from here. Thank you. On the law issue, until recently, I think that I stand to be corrected, but I think that human rights is an elective in the training of lawyers. Until recently, I think it wasn't even done at all. I think a couple of years ago, maybe 5, 6 years. I stand to be corrected, but it's not a focal area in the training of lawyers. And there are a lot of lawyers on it. Harrier, you are here. I've seen Richard. I've seen a couple. Edmond, you are here. Correct me if I'm wrong. But when I started in civil society work, most of the lawyers were not trained on human rights law directly, or the African. In fact, the African systems, I think, is not something that is happening. It's not happening at all. I stand to be corrected too.
No, you're correct, Mina. You're right.
Okay, so I'm just wondering if we could...
Mr. Ibe, may I make a...
Yeah, please go ahead, Aria.
Right. So speaking directly to the contribution that came up on plea bargaining, right? Like I said, it's a step in the right direction. Like all these other reformative conversations seem to be going. But if you look at the substance of the law, it simply says that the offenses could be withdrawn, there will be lesser sanctions, so and so. But there are no provisions for those lesser sanctions, right? Like I mentioned earlier, you can put in something like fines, but if there's a default, you are going back to prison. Do you get? So in as much as the plea bargaining law is a good idea, it's great. And when it is applied to minor offenses, amazing. But we have not put in the proper structures, the alternative sentencing regimes, plea bargaining amendments, substantial and have any sort of effect, because it would work great in the felonies, the bigger offenses. But when we come directly to minor offenses, we have not put in the structures that would ensure that this plea bargaining amendment would have any effect at all.
So can I ask you on that point, Harriet, what kinds of structures are you thinking about?
So I mentioned earlier that we need to be looking towards probation, community sentencing, rehabilitation, different sanctions that we can say that, oh, you were punished for what you did, but not big enough for you to have to go back to prison. Please. Yes. So that's what I mean. We haven't put in the laws, so we need to go back to our foundation, right? And then get people to think more of these alternative sanctions, right? Which is great, but we don't have the structures. The judges do not have the authority to minimum sentence sentence is still harsh, because eventually, if you are not able, if you default, you are going back to prison, the entry point of these things, but also putting the structures to ensure that all these things, because the laws need to make provision for these alternative things, would make any substantial impact.
Nick, can I comment on the plea bargaining as well? I was just thinking while I was listening to Harriet.
Hello, Luis.
I'm just saying, I just was thinking about the plea bargaining question. Can you hear me? Yeah. And I just wanted to say that in addition to the alternatives that Harry is mentioning, when we talk about structures, I think the thing that concerns me about plea bargaining in Africa is that I think the intention, well, in other places as well, but the intention is good. But if you look at how dysfunctional some of our criminal justice systems are, and the problem around equality of arms, if, for example, somebody has a really strong judiciary, but they don't have any access to lawyers, or if the prosecution is really strong and the other two are not, the likelihood that the person who is entering into this agreement is going to come out with a fair sanction is very low. And I think you mentioned this at the beginning, Stanley, is invariably white collar crimes, people who've got money manage to navigate the plea bargaining system and come out the other side, with a favorable outcome. But what we find is that many people who are poor get railroaded into, pleading guilty when maybe they didn't need to. There's also a high probability of corruption. So I think to Harriet's point around the structures and systems that need to be put in place, I would just say it's a great idea, but we really have to make sure then that all parts of the criminal justice system are working equally for it to work. And I would also say that some level of oversight and accountability needs to be in place, and some kind of review process if we are going to use that as a primary way of adjudicating cases. And I am a supporter of plea bargaining and what we call in South Africa plea and sentence agreements, but they rely very much on, as I say, the equality of arms. Otherwise, they can be very problematic.
So that's precisely the reason why I asked Julie to pack the question about plea bargaining. Julie.
All right, thank you. And I completely agree with everyone who said that there are challenges with plea bargaining. It isn't the silver bullet. Plea bargaining requires a lot of oversight, requires some extent an appreciation that there is a power dynamic in that negotiation. Prosecution is offering them a way out of that charge or a reduced sentence, but if not held accountable, or if no oversight is provided, then unfortunately this person would be bullied in to that agreement, may actually disadvantage them in the long run, because potentially had they have had sufficient evidence to convince that the person is guilty or innocent of the charge. So there is a power dynamic there. And it was just one of various things that could be considered. I wanted to just highlight the other forms that could be considered. So I talked about extensively around community service orders. There is also probation orders, affordable fines and not punitive fines. Payment for compensation in certain issues, absolute and conditional discharge. I would really look forward to the day that someone is actually absolutely discharged. Conditional discharge. You come to the court, you say why you committed a particular crime and what are the factors that led you here, and the court says, indeed you're guilty, but we discharge you, because we can do that. And this is one of the interesting provisions within our penal system that is actually not used it's not really used. We also have suspended sentences. Suspended, they find you guilty, and the charge that you potentially would, the sentence that you be, but the court will tell you that we have suspended your sentence. So in the interim, we will review your time. After you have exhausted X amount of time, maybe 6 months, then we will have suspended your sentence in totality because the court can devise such a special mechanism. I am referencing the sentencing policy guidelines that we launched on the 1st of September. The matter is in regards to maybe a driving issue or a licensing issue. It can just be a suspension on your license. And then you reapply after 1 year after you've complied with all the driving regulations and reapplied to driving school. So I am bringing all this to show that judiciaries across the board and actually criminal justice sectors, actors across the African continent can look at their own criminal justice systems and devise it to suit the people that they serve. The law is for the community and for the people who it serves. So within our country, we have looked at all these sentences as appropriate sentences. Of course, there is still bad abolition, but what we are doing is ensuring that we can customize sentences for the public. And that is why we're also looking at, whereas the sentences have been very well kitted to look at minor and petty offenses, we are also looking at the fact that they ought not to be the system in totality. So looking at diversion, looking at alternative justice systems, looking at decriminalization in totality of the various laws that brought them into the system. So we are looking at the holistic reform, but in the interim, if they do go before a court of law, looking at how the court can then use its discretion on sentencing to ensure that this person does not get a custodial sentence, but gets a sentence that is considerably proportional. Yes, the word is proportional to the action that they have committed. I do not believe a person who has stolen a chicken can be equated to a person who has stolen a vehicle. Circumstances may be different, but you cannot treat these people with the same law. So how then do you keep the law to ensure that you do not discriminate against certain people? A critical issue that we have unpacked in our criminal justice system is the fact that not every single person is represented by an advocate. So we have been working with the National Legal Aid Service to look at how they can ensure that advocates or paralegals are there to represent clients who go before these courts. But indeed, there is a big challenge because a lot of poor and vulnerable people do not have access to advocates, more often than not have access to paralegals and end up self-representing. So what we have also been doing is ensuring that information is disseminated in various police stations around what are the various options in terms of getting a paralegal, but also in a position, unfortunately, to go before the court and ask the court to represent you, to tell your story for the court. But since you're self-representing, tell the court what has led you to this position and seek guidance even from the process. Say, I am ready to say that indeed I committed a pardon because it is one of the sentences that is appropriate. You can give a caution, you can give a pardon, or you can also just give a non-custodial sentence, particularly.
Criminal Code. So now I want to ask, and before this program, there was a preamble relating to the flight that was shared for us to look at. GBA recently in their conference in Cape Coast were asking the government to look at petty offences and see how best they can work around it. My question goes to, how can we do this if the criminal code is not reviewed? And what is the state of the criminal code that has been reviewed in Gambia some time ago? What is the state of it? Thank you very much.
Thank you very much.
Yeah, thanks. So let's do this. We'll try and close out at this point. So Edmond, you respond to that as you close out. If I can ask each of you to give us your closing remarks in about a minute and a half at the most.
Right. Thank you very much, and thank you, Aremiao.
I think you are jumping the gun.
Pardon?
I think you are jumping the gun.
Oh, I didn't mind Mr. Foley going first, but I'll just close by saying that I think that this discussion has been very fruitful. I appreciate the fact that I have been able to learn so much because I haven't been in this space for as long. I appreciate the insights and it's been very helpful. I hope that, and I'm very sure that the things that I have learned from here can be used to help re-strategize and then get some impact in these petty and minor offenses in Ghana. Thank you very much, everyone, for your contributions. I'm very grateful for having the opportunity to learn so much from so many knowledgeable people. Thank you.
Thank you, Haria. Can we go to Luis? And Luis, if you can touch on the changing hearts and minds thing, that would be great. Closing remarks.
Okay. I'm going to say in my closing remarks that often when we talk about criminal justice reform, there's a sort of a sense of doom and gloom, and there are people who will tell us, and I remember somebody saying this to me, it's impossible to change. But I always want to say to people that, when you've been around for as long as I have, you can see that change is possible. Because I can look back and I can remember no separation at one stage of pretrial and sentenced prisoners in many places. And now you won't see that. There was no separation of children from adults, and now you'll see that. There were almost no child justice acts on the continent, and the implementation of diversion programs, in many, many places across the continent. So, I could go on, and also the reversal in the death penalty. So just remember that it actually is possible. And, where things have really worked is where we've worked together and where we've shared our learning. So these kinds of webinars are incredibly important because not only do we share ideas and learn from each other, but also, get to, identify new people that we didn't know before who are in the space and who are being thoughtful about these issues. So I just wanted to make that point, and all of the kind of constructs that we talk about are kind of, either nascent or starting to develop or are well developed in places. I also wanted to make the point somebody had asked the question, Stanley, in the chat, and a point around, next step might contain, for example. So I think Facebook could be useful in another point around the hearts and minds. I don't know what works, but I do know that where people have been consistent in pushing a message, like, for example, Kriya in Malawi, just making sure that they were engaging with journalists, were, creating messaging in popular media that was speaking and sending a different message. They've certainly seen an uptake in all of that. So there are many different ways to change hearts and minds. I think that there are different audiences and you've got to target your message for those audiences. But I just wanted to end on a positive note because I do think that, in real time, I've seen changes. I know other people have seen changes, and the situation for me is dramatically different to what it was when I first started working on criminal justice in the 90s. So Thank you.
Thank you, Louise. Edmond, 90 seconds.
All right. Thank you very much, Stanley. So quickly, yes, there's a very good draft of the Gambian criminal offences. It's called the Criminal Offences Bill of 2020. Sadly, Arimeya, it's not been passed yet. But also to say that, yes, following that workshop, we have seen at least some positive engagement by the parliament to do something about it until just a couple of days ago when they are talking about repealing the FGM law, for instance. So we are back to the drawing board. The advocacy continues. I think that's the resounding call that we should not lose hope. It's not doom and gloom. And so we are here to keep up the fight. Thank you.
Thank you, Edmond. Julie, you have the last word on the panel.
Thank you. Thank you. I think I will follow the trend and end on a positive note. I think there is so much that the campaign on petty offences has done to change the narrative on the continent. And I am sure that that narrative that has since been changed can actually now move into the national sphere and affect the national conversations. I would challenge each one of us to collect information, collect the data, collect the numbers, because numbers and data are very persuasive. Now, moving from the data and the numbers, look at the humans behind the data and the numbers. Tell their stories, document their stories, and not only do that, but engage the media in doing so that you can have as many people talking about it. I think one thing that I really appreciated with our campaign in Kenya around the question of petty offenses is that once we got the media involved, every single journalist was running with this story because it touched on the heartstrings of everyone, because they saw themselves as a potential petty offender. They saw themselves being potentially victimized by the continued existence of these laws and wanted to tell the story of the people who are living these experiences. And showcasing this in mainstream media and in alternative media and in social media allowed us to get such, allowed us to get such visibility on the issue, therefore allowing us to reach greater audiences. Sorry, there's a bit of disruption, so struggling a bit. Thank you. So back to that conversation around documenting the stories and ensuring that these stories are told in various platforms. I think sometimes when we talk to judicial officers around statistics, facts, and laws, and various provisions that we want to deem unconstitutional, it is important for them to have had and seen and felt the reaction from the public around the continued implementation of these laws. And that is why I'm very big on documentation, on documentaries and telling those stories, because they need to see the impact of the work that they are doing in common lives. Police officers and prosecutors often do not understand why some of these things are really being championed by civil society organizations until they hear the stories of people with lived experiences. So that is something I would really challenge all the actors who are here to consider doing. Tell the stories and tell them loudly. Ensure that they are carried by various platforms, and ensure that after that has happened, push for those conversations with legislators, push for those conversations with policy makers. Be audacious. Seek audience with the presidents. Why not? Because sometimes when you look at the manifestos of particular presidents, and in our case, the current president of the Republic of Kenya ran on a manifesto that is pro-poor people, pro-vulnerable. He was very interested around how he can support it because it does feed his political narrative. And at the end of the day, we want to ensure that these laws are passed nonetheless. And these are the various platforms that you can get the various people who have the power to make change actually implement that change. So that will be my takeaway from here. Thank you everyone for the interesting conversation. I have really learned a lot from Ghana, and we are, as ICJ Kenya, ready to support and lend our resources to ensure that you can also move towards potentially decriminalizing minor offenses and petty offenses within your country. Thank you.
Thank you, right on time. We have to close now. Let me say that the best part of a meeting like this is what happens the day after. So I'm hoping that CHRI and all the colleagues of the organizations involved in this can actually take what has come out of this meeting and run with it. On that note, let me hand over to the colleagues at CHRI to close the meeting. Mina?
Okay, and thank you very much, Stanley. I must say that this has been a very interesting conversation. A lot of lessons, a lot of takeaways have been learned. I think that this would strengthen the advocacy in Ghana. Interestingly, we are an Africa-based Commonwealth country, so Kenyans are our sisters. So, Julie, going forward, we'll be doing a lot of work with ICJ to pick up from a lot of the lessons, because you have implemented quite a number of these things. Kenya, when it comes to non-custodial sentencing and these alternative dispute resolution issues, you are very much ahead, and we would engage so that we see how to take ours forward. I would want to also say a big thank you to Edmond, to oh, why have I suddenly forgotten her name?
Louise and Julie.
Louise, I've already said Louise, and Haria, for being available to speak to us and to share your knowledge. I say thank you to all the participants, all those who contributed, and the questions. We promise to take this forward, engage, and ensure that this is not one of the talking shops that we do, but something that we can concretely put our hands to, and do another webinar next year around the gains that we had from this meeting. So thank you so much, everybody. And since it's 2 o'clock in Ghana, I don't know what time it is wherever you are, but have a good afternoon and enjoy your lunch if you haven't had lunch yet. Have a good day. Thank you. Stanley, I'm done.
Yeah, that's it. You have the last word. Have a great day, everybody, wherever you are.
Thank you very much, Stanley. Thank you, everyone. Bye.
Interestingly, I forgot to mention Edmond.
I love Twinkies.